Construction Limited was contracted to build a commercial complex. As part of the project, they hired Elite Engineers Limited to inspect and certify the structural foundation. Relying on the engineer certification, a retail company, Freshmart, entered into a lease for one of the units, investing heavily in fits out and marketing. 6 months after opening, serious structural defect was discovered, requiring the entire building to be closed for repairs. Although Freshmart did not suffer any physical injury or property damage, it lost substantial income, incurred costs relocating to temporary premises, and had to cancel supply contracts. The defects were eventually traced to Elite Engineers' negligence certification. Freshmart now seeks to recover its loss from Elite Engineers. The issue arises on whether Freshmart Limited can claim for recovery of pure economic loss from Elite Engineers Limited.
Assalamualaikum and hi, my name is Muhammad Fahim. My metric number is 300448. So I'm going to discuss in the case of Eastern Pacific Industrial Corp Berhad against AD Metal Trading and Transport Sdn Berhad 2025, 3rd MLJ 111. So the fact of the case is that this appeal case involved a dispute between AD Metal as the plaintiff and also Eastern Pacific, which is the defendant. So AD Metal had a contract to transport scrap metal from Kemaman Supply Base to Hayat Lestari, but was blocked by the Eastern Pacific security team. This caused AD Metal to lose its 200,000 deposit, waste money on unused truck, and miss out a potential profit. So AD Metal sued for damages, including 300,000 in loss of earnings, while Eastern Pacific denied responsibility, claiming it didn't control the auxiliary police or the site. So the court applied the capital test to determine if Eastern Pacific was liable for AD's metal losses, assessing whether the harm was foreseeable if there was a close relationship between the parties, and it was fair to hold Eastern Pacific responsible, since blocking AD's metal lorries clearly causes financial harm. The court ruled that AD Metal could claim either its actual cost, like the RM 200,000, or the loss of profit, but not both. So the trial judge awards 300,000, which is the total potential earning, was incorrect because it didn't account for expenses. The proper net loss profit was 170,000 after deducting costs such as truck rentals. Ultimately, the court awarded 207,324 to cover AD Metal's proven losses, emphasizing the pure economic loss must be foreseeable and directly caused by the defendant's action, with damages calculated precisely, not just based on estimation.
So the second case is in the case of Sunrun Hill Sdn Berhad and SWM Quintet Sdn Berhad and Anwar in 2023, where in this case the appellant Sunrun Hill operated a water treatment plant, or known as WTP, near a Sungai Benut in Johor by extracting and selling the treated water. And later, the respondent, SWM Quintet, and another company were the operators. However, they are not the owner of the landfill that was located near the upstream from the water treatment plant. So between the November 2016 and January 2018, the water treatment plant was forced to shut down 8 times due to high levels of ammonia and other pollutants in the river. So the appellant sued the landfill operators, alleging that the untreated leachate from the landfill, especially during the heavy rainfall when the landfill sponge broke, was the main cause to the pollution that led to the shutdowns. It is supported with the evidence from the expert that the landfill was the primary source of the pollution, although there were other minor contributors, and the appellant's claim was for poor economic loss, specifically financial losses from the forced shutdown without any accompanying of the physical or property damage. Court of Appeal unanimously allowed the appellant's appeal by setting aside the High Court's decision because it was found that the respondent were liable for the negligence, as the pollution was foreseeable and the leachate spillings was the proximate cause to the water treatment plant to be forced shut down. However, under established relating to the Part 4 test and the limitation in the recovery for poor economic loss under the law of torts, where the recovery for the poor economic loss does not allow unless it is consequent upon a physical damage or injury. So despite this, since the negligence was proven, so the court awarded nominal damages to the appellant of 100,000 ringgit by recognizing the seriousness of the breach even though the full economic loss could not be recovered.
So, hi, my name is Valerie Abigail Analista. My matrix number is 300798. So today, we are discussing the recoverability of pure economic loss in Malaysia, particularly in the cases of negligence mistreatment. In Malaysia tort law, the general position is that the pure economic loss is not recoverable. This means that financial losses are not tied with physical injury or property damage are not typically compensated. But there are some exceptions, most notably in the cases involving negligence misstatement. This is where a party suffers financial loss due to relying on an inaccurate statement that is made carelessly. Consider this: Elite Engineers Limited provided a structural certification and Freshmart Limited relied on this certification that suffering significant pure economic loss when the building was deemed unsafe. This scenario perfectly illustrated a negligence misstatement claim. To successfully claim for negligence misstatement and recover pure economic loss in Malaysia, we will look to the principle established in the landmark case of Hadley, Bryan & Co. Limited and against Heller and Partners Limited. This principle has been adopted and applied in Malaysian law. So right now, we are going to say about key elements for pure economic loss. So the first one is special relationship. A special relationship must exist between the parties. Elite engineers, as a professional structural engineers, possess special skill and knowledge, and their certification are inherently relied upon. This clearly establishes a special relationship with Freshmart. The second one would be voluntary assumption of responsibility. The party that making the statement must have voluntarily assumed responsibility for the accuracy and the care with which it was made. By providing a certification, elite engineers can argue to have voluntarily assumed this responsibility knowing it will influence Freshmart's decision. The third element would be reliance by the recipients. Freshmart explicitly relied on elite engineer certification. They entered into a lease and invested heavily in the premises based on the assurance. The fourth and the last element would be reasonable and foreseeable reliance. Freshmart reliance was entirely responsible and foreseeable. Any retail company would rely on a structural engineer certification before investing in a commercial unit. And the last one would be resulting damage. Finally, this reliance must have resulted in damages. Freshmart suffered substantial economic loss, relocation costs, and cancelled supply contract, or are constituting to pure economic loss directly stemming from the reliance on the fault certification. Therefore, Freshmart Limited has a strong basis to establish a claim for negligence misstatement against Elite Engineers Limited and recover their pure economic losses given the clear fulfillment of Hadley-Bryan principle.
Next, we move to the applications. Freshmart Limited incurred pure economic loss due to the Elite Engineers Limited negligent structural certification. Even though there is no contractual relationship between the two companies, duty of care can be incurred in tort where a negligent misstatement has been made and reasonably relied on, as held in Hadley-Bryan and followed in Malaysian law. Elite engineers certified here the commercial complex structural safety in their official duty. It was all expected that such potential tenants as Freshmart would use the certifications into money if they would lease and invest in the building. Freshmart did just that with huge amounts of money spent on the marketing and fits out based on structural stability guarantees. The Court of Appeal ruling in Eastern Pacific Industrial Court Berhad and against AD Method Trading and Transport Sdn Berhad upheld this position whereby pure economic loss liability was upheld since harm was foreseeable, relationship intimate enough, and loss directly linked to Defendants Act. The certifications of elite engineers also directly contribute to Freshmart loss, meeting the requirement for closeness and foreseeability. Even though St. Van Hills, Sdn Berhad against SWM Greentech, Sdn Berhad and another upheld the general rules against recovering pure economic loss, the court then nevertheless granted nominal damage because of the demonstrated negligence and foreseeability of harm, indicating that Malaysian courts are prepared to acknowledge liability when a professional's negligence has obvious and immediate financial consequences. Freshmart reliance on the engineer's report was precise, reasonable, and expected, in contrast to San Juan Hill, where the plaintiff reliance was less direct and concerned environmental pollution. The facts of the case include the presence of negligent misstatement, reasonable and foreseeable reliance, and clear economic loss, which support the finding that elite engineers owes a duty of care to Freshmart and that Freshmart may recover its pure economic loss.
In conclusion, Freshmart Limited can claim for recovery of pure economic loss from Elite Engineers Limited. Although pure economic loss is not, as a general rule, recoverable in Malaysian law of torts, there are exceptions where there is negligent misstatement by professionals. Elite engineers gave structural certification which was reasonably and foreseeably relied on by Freshmart. So the proximity and the direct link of the negligence and loss of evidence are existence of a duty of care. So based on the recent law case, the courts are likely to hold elite engineers liable for Freshmart loss.